Welcome to Design Domination, where you'll gain confidence, clarity, and a competitive edge in a crowded marketplace so you can dominate your competition. Hi, and thanks for tuning in. I'm Colleen Grotzer, and in this episode of Design Domination, I'm talking about the lawsuit that has rocked the accessibility industry, the SLAPP heard around the world that has the accessibility community in an uproar. And that is the lawsuit of AudioEye versus Adrian Roselli. Okay, so let's take a look at who the parties are. And disclaimer, I am not a lawyer. This is not legal advice. This is my personal opinion based on the research that I've done on this case and the ones that I also mentioned as well. Okay, so AudioEye. AudioEye was founded in 2005 and has been in the accessibility space for more than 15 years. They have patented AI and automation, which many people may refer to as an overlay. And they also offer audits and other services. Now, I've talked about overlays before on the podcast. A web accessibility overlay is put on a website by adding a line of JavaScript code to the site with the purpose of performing automated accessibility checks and fixes that are on the front end of a website. And they don't affect the underlying code, which is where the issues lie. Now, Adrian Roselli is a prominent and well-respected consultant, writer, and speaker in the accessibility world. He's been involved in accessibility for 30 years, which is way more than most people, and I have followed him for years as well. He's also been a member of many W3C working groups, community groups, and task forces. So his resume is quite extensive and impressive, to say the least. And he's always been very generous and thorough when sharing his accessibility insights. So no doubt that he is definitely well qualified when it comes to accessibility. So AudioEye is suing Adrian because pretty much they don't like what he has said about their overlay product, and they assert that he has targeted their customers with his comments. Now, Adrian has been very matter-of-factly, I think that's a word, matter-of-factly documenting the legal battle on his website, adrianroselli.com, in an article called AudioEye is Suing Me. And he's even been including the documents for people to be able to review. Now, on April 5th of 2022, AudioEye issued a cease and desist letter to Adrian. And in that letter, which appears on his website in the article, My Cease and Desist from AudioEye, they claim that Adrian was spreading, quote, materially false and disparaging information intended to injure AudioEye's reputation, malign its products, and destroy its customer relationships, end quote. They also had a problem with him allegedly not making mention that they provide more than automated solutions. But since when are you obligated to mention all the services that a company provides? So I don't know. Then they cited his tweets to JD Power in particular as an issue. They said that Adrian stating that AudioEye, quote, does it work, unquote, is false and therefore defamatory. And they also took issue with him linking to the Overlay Fact Sheet and Overlay False Claims websites. They demanded that he remove what they said were defamatory posts and, pretty much shut up. A few days later, Adrian allegedly got a follow-up letter because he didn't remove the tweets. So then they threatened legal action if he didn't do that. So Adrian responded by saying that he had gone ahead and deleted the tweets about JD Power, even though he still believes what he said about AudioEye was accurate. So then he goes on to address the points in their letter, saying that he was not trying to spread false information or be disparaging, but only to help end users and the information on which he bases his opinions. And then he signed off with annoyedly, which is pretty funny. Okay, so then in February 2023, Adrian published AudioEye Will Get You Sued. And then in March, Adrian says that he was served with legal papers. It was a 30-page lawsuit and ironically not available in a digital and accessible format. And then in May, an attorney for AudioEye sent an amended complaint to his attorney, and that was an inaccessible PDF. It was untagged. And the amended complaint mentions critics of overlays in general, and then calls out Adrian specifically and accuses him of doctoring videos and giving a false impression that AudioEye as a whole, not just their automated tool, quote, does not work, unquote. And then they refer to it as a smear campaign against AudioEye. They mention certain Twitter accounts. They mention well-respected web accessibility advocate Carl Groves, a disability rights lawyer Lady Feingold, too. And then in July of this year, Adrian's attorney filed a motion to dismiss the case based on New York's anti-SLAPP law. SLAPP, S-L-A-P-P, stands for Strategic Lawsuit Against Public Participation, Well, Lainey Feingold, again, a lawyer, has said that a SLAPP is, quote, a type of lawsuit that targets activists in a number of fields around the globe, end quote. And then she goes on to say that, quote, a SLAPP suit is a slap in the face of the person being sued for participating in a public issue. And it is a threatened slap in the face for everyone else participating publicly in that issue, end quote. And then affidavits and affirmations in Adrian's support have been filed from Adrian himself, Norbert Rum, Rian Rietveld, Leonie Watson, Steve Faulkner, and Ian Hamilton. Now, what's really interesting is that former Congressman Tony Coelho, who was a primary sponsor of the Americans with Disabilities Act, serves on AudioEye's board of directors. You can download some of the legal documents from the AudioEye versus Adrian Roselli case from his website. And I have links to all of the ones that I mentioned in the show notes on the episode page at creative-boost.com. Now, it might surprise you that there have actually been other lawsuits against public opponents of overlays. One is a French accessibility overlay company called, and even though I have a background in French, I'm going to butcher this, I'm sure, Facility, allegedly sued French web accessibility advocate Julie Moynat in France's version of a SLAPP. So she went and expressed her opinion on Twitter as an individual, not on behalf of her employer, and that was in response to another tweet. And then Facility, or rather their lawyers, sent a letter to the company that she worked for in December 2020. Now, something interesting to note here is that her tweet allegedly only had 9 retweets and 32 likes. So it's not like it had gone viral or anything like that. So she deleted the tweet, but then in March of 2021, her employer got another letter. And then 2 months later, she was allegedly served at her residence. And the company, Facility, was seeking 10,500 euros for damages and fines. And from the update posts about this case on her website, it appears that the matter is still ongoing. Now, another target was, I think you say this, Koena, Koena, a French digital accessibility company. And in April of 2021, they allegedly got a letter from Facility's law firm citing an issue with their tweets. And then a month later, they got another letter. And then in June that year, they were summoned to court. Well, Facility wanted them to remove 2 tweets and pay 5,000 euros in damages and 6,000 euros for legal fees. Now, on another note, but a very interesting one, is that AudioEye recently acquired the Bureau of Internet Accessibility. I want to hear from you what you think of all this. And here's my opinion. Again, this whole thing has been my opinion, but here's my opinion. These overlay companies get tons of funding. And here's 2 cases that we know of where they've targeted individuals, not companies. And, you know, when you target individuals, most of them are maybe not able to defend themselves, right? But that makes me wonder how many others have there been that have not gone public? You know, did they just remove their comments and it was done? Did they settle out of court? Did they have to pay something? And, you know, it also seems to me that companies with an automated product such as an overlay, you know, overlays are things that have been getting a lot of criticism. It seems to me that some of these companies could learn from the comments that they've been getting and use that information in order to make their products better, right? And they could also maybe take it as a sign to make their marketing clearer about what an overlay or a toolbar or whatever really can and cannot do. But silencing comments that they don't like from experts or even end users certainly doesn't help the end users. And that's the whole point of accessibility. So I'm going to continue to follow Adrian's case, and I do hope that it gets dropped. And cheers to Adrian for standing up against this and fighting the good fight and standing up for accessibility. If this content was helpful, you can support the podcast by buying me a coffee. It might actually end up being a glass of wine or some tea, but you can go to buymeacoffee.com/creativeboost.